This is exciting.
On Zapeda. Ian McCray, are you ready? Oh, do we have a Spanish interpreter? No. We do have a Spanish interpreter? No. Okay. He's coming out any second.
We only have one still, one here. I'm going to let them know only one still, one still.
I think you can have more than one still. He's allowed to film. Judge Duke.
All right, please.
Afternoon.
Who are you?
Good. I'm just trying to find two people. Oh, we do have a Spanish interpreter. Are the parties ready on the 58A of Zapeda?
Good afternoon, Your Honor.
Good afternoon. How you doing, Mr. Doucette?
Very good, Your Honor.
Good. Nice to see you.
Yeager, she's a
How are you?
V303 intern who
Great.
to assist, who also fluent in Spanish, but we did order a Spanish interpreter.
And Madam Interpreter is present. Number 15 on today's list, 58A of Albert Zapeda Sepulveda. I apologize for that pronunciation. He is in custody. Will be brought in momentarily.
What number is this? 15?
It's number 15.
Okay. Hi, Mr. McCray.
Good afternoon, Your Honor.
The parties could, well, Madam Interpreter, have you been sworn today? Good afternoon, Your Honor.
Oh!
Thank you. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Keith McCray for the Commonwealth.
Afternoon, Your Honor. Francis Doucette for Mr. Zapata and with intern Bianca Yeager.
Can I see the papers?
Good afternoon, Your Honor. Bianca Yeager, 303 from BU.
Nice to see you.
Is there more for the district court record?
Yeah. You don't get probation here, I don't think.
She was just here.
Yeah.
We'll get her.
Buenas tardes, yo voy a ser su intérprete.
We could ask, does the court need a copy?
Okay, all parties are present.
Okay.
Before we begin, Your Honor, does the court have a copy of the police report?
Yeah, I got it. I just read it.
Oh, all right, very good, Your Honor.
Mr. McCray, tell me about the case. Got 90 grams of coke and supposedly a warrant from California.
Yes, Your Honor. And in addition to that, the Quincy Drug Control Unit was setting up surveillance. They noticed that this particular meeting happened in the parking lot of Father Bill's, which is a shelter in Quincy. And once they were, one thing that the Quincy DCU does whenever they can is when they see a deal like this, when the parties separate, one group follows the purported buyer, one group follows the purported seller.
Yeah.
They did get confirmation from the buyer as to what he bought and how much he paid, and after that,
Am I in the wrong room by any chance?
Stopped.
Hold on.
There was a canine alert to his crotch area. However, there was no drugs recovered
Let me
from
just
his
double
purse.
check. All right, how do I join a room? All right. Okay. Don't connect to, well, turn off my video for sure. Okay, let's see if that does me any good. Okay, maybe I was in the wrong room. Okay. Exciting. Miss Bandy, you sent me the number. Oh, yes, I understand. There are cases in front of him?
To ask him if they ever received the warrant. They said they didn't. They never got the warrant from HSI. I tried to reach out to HSI today as well, but I did not hear any response from them.
Anything
But I do know, based on the review of his III, at the very least.
All right, I guess we're going to learn about the 90 grams of cocaine for a while.
Removable alien charge against him stemming from 2022.
Okay. All right. Mr. Doucette.
California warrant.
My logo's out of date.
Fiction, Your Honor. I will let Ms. Yeager continue with the.
Yeah, go right ahead.
Sure.
Thank you. Good afternoon, Your Honor. When considering the factors in the statute, it is clear that the prosecution cannot possibly meet their burden in this case. As Your Honor very well knows, there's a presumption of innocence here in these types of cases, and there's a higher burden on the prosecution of proof for clear and convincing evidence.
Tell me a little bit about him. What does he do? Where does he live? What's his status? Tell me the whole thing.
Certainly, Your Honor. Mr. Zapata lives in the area. He has no prior criminal history record in Massachusetts or any other state.
Where does he live? Or who does he live with?
Mr. Zapata had been staying previously in Lynn, I believe.
Okay.
My apologies, Your Honor, in Mattapan. However, at 3 Orlando Street in Mattapan, and he has several family members in the area as well that he mentioned he'd be able to stay with if Your Honor were to release him today. As I was saying, Mr. Zapata has zero criminal history record in Massachusetts, any other state. We ran his III record, which came out completely blank. So as Attorney Doucette was mentioning, this charge from California seems to be entirely fiction. There is also no fugitive from justice complaint. None of that was ever brought forward. And as prosecution mentioned, there was no successful contact from HSI or Special Agent Fernandez following attempts to follow up. During the alleged incident, Mr. Zapata exhibited no violent nor dangerous behavior when he was apprehended. He cooperated with law enforcement, as is indicated in the police report, where it says he was arrested without incident. The only words that Mr. Zapata uttered was no English to indicate his limited knowledge of the language.
He doesn't speak English, but he speaks
Zapata
cocaine.
had no weapons on him when he was apprehended. He made no attempt to flee. There was no threat of violence. Mr. Zapata also has zero history of mental illness or drug dependency, and there was no hint of any kind that he was under the influence of any substance on the day when he was arrested.
How much bail can he make?
I've spoken with Mr. Zapata. He says somewhere around $10,000 or so, if possible.
$20,000 cash bail.
Mr. Zapata
Surrender
also...
his passport within 24 hours of release.
We have an ex-date of July 17th.
$20,000 of bail for 90 grams of cocaine.
Thank you.
Thank you, Your Honor.
Okay.
So,
All right.
after hearing, the court orders you to recognize in the sum of $20,000 cash with the following conditions. Surrender your passport.
$20,000 cash
within 24
only, though,
hours
is
of your
painful.
release.
Because that means he has to show up with
Consent to that
$20,000.
condition, sir?
That's kind of painful.
Thank you.
Yes, thank you.
Thank you.
You're hereby notified if you charge with a crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Laws, Chapter
And he can't even sell the 90
Section
grams to
58.
get the $20,000 anymore. That's very sad.
Thank you. Have a nice day.
Your Honor.
Nice to see you. Mr. McCray, always a pleasure. Take care.
Good to be back.
Are we ready
Good to be back.
on the Carney matter? Okay,
Carney.
This one?
we're gonna do Mr. Carney. So next,
Here we
before the
go.
court, number 6, 7, and 17. Number 6 and 7 are on for status. Number 17, which is 25 CR 88, is on for arraignment. So please come forward and identify yourselves for the record.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Good afternoon.
Hello, Your Honor. Timothy Bradel on behalf of Aiden Carney. To my left.
Good afternoon, Mr. Carney.
And Mark Federer for Mr. Carney.
Hi, Mr. Federer. Good afternoon. Okay, let's arraign him on the new case.
A new case. How many cases are there, ma'am?
On May 13th of 2025, the grand jury sitting in the County of Norfolk returned indictment number 2582CR00088, charging you as follows. Offense 1, charging intimidation of a witness, and offense 2, charging intimidation of a witness. Do you wish to waive the formal reading of these indictments?
Yes.
How do you wish to plead to each of these indictments?
Not guilty.
Thank you, sir.
Okay.
Is there a question of bail?
There's no question of bail, but I would ask the court to impose the same conditions that were imposed in the Stoughton District Court. And Mr. Bradel, correct me if my memory is wrong. I believe it was no contact with the alleged victim and stay 100 yards away from his place of work and residence.
And what are the allegations on these, on this one?
Intimidation of a witness, Your Honor.
Yeah, but what's the nature of it?
This was the appearance outside.
Oh, outside the waving in the pizza shop. Yeah, I remember this. All right,
Judge, that's agreed under Section 87.
yeah, that's fine. All right, I'll impose that, Margaret.
Thank you.
Would you like me to do that now or wait till the end?
Why don't you do that now? Just do them one at a
All right,
time.
the court recognizes you personally without surety with the following conditions. You are to have no contact, direct or indirect, with the victim in this case. And you are to stay away, have no contact, stay away 100 yards from the residence and the place of work of the complainant. Do you assent to those conditions, sir?
Yes.
And you're
Okay.
hereby notified if you're charged with a crime during the period of your release, the bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58. Thank you.
All right, what else are we going to do?
Judge, if I may jump in right there, just for the record, we filed 2 arraignment-related motions, Your Honor.
Okay.
Obviously, we can push those to another day with 2 small exceptions of just an order to preserve notes of investigators and to preserve video, if I may, Your Honor. I don't believe there's an objection.
Okay. Yeah, those are both ordered. So we saw the Commonwealth's ordered to preserve notes of investigators and to preserve video.
We're going to preserve video
What
this
else can I
time?
do for
That
you?
sounds like a good idea.
For me or?
Why don't I start with you, Mr. Cosgrove? Go right ahead.
All right. So Your Honor, answered a discovery order the last time we were here. I've made substantial progress on it. I can't say I fully complied with it, but I have about, let's see, somewhere in the neighborhood of 5,000 or 6,000 pages of discovery to provide
Really?
Mr. Bradel today.
6,000 pages of discovery?
To file that with a
What the
motion
fuck?
for a protective order.
6,000 pages of discovery?
Which I had,
Jesus Christ.
I had served on Mr. Bradel a couple of days from the one.
What are they writing about? Damn.
And we have been going along with these, essentially tracking protective orders in the Karen Reed case, and in fact, much of the material is duplicates of the discovery turned over in the Karen Reed case, and I pretty much follow their form protective order. These have all been allowed with the agreement of the defendant and without prejudice.
Okay.
I understand that Mr. Bradel wishes to bring that practice to an end as of today. I'm in a somewhat different position.
All right, let me hear from Mr. Bradel. Mr. Bradel,
Thank you, Your Honor.
give me your argument.
I appreciate it, Your Honor. Judge, the Karen Reed case is over with. It's moot. It's gone. Okay?
Thank God.
And my filing, Judge, entitled Aiden Carney's motion to release case documents from impoundment is what we're talking about here, Your Honor. So I asked the court last time, and we had so much business on the docket last time, I don't think we circled back on it, but I was asking to just release everything from impoundment, Your Honor. The fact that things are embarrassing or scandalous or cause negative light to be cast upon public officials, Your Honor, is not.
Yes, I'm very muted. They can't hear me.
Documents. It's
They could hear me,
actually
that'd be a real
reason to
problem.
release documents, and that's really all the Commonwealth has left on the existing stuff. Is that, gee, this might make investigators look bad. This might make special prosecutors, present company accepted, look bad. This might, cause election shifts, and that's not a reason to impound things, Your Honor. And initially, we have sort of taken the candy from, from the Commonwealth, and when they say, we'll give you the stuff, but just agree to this protective order. So we want the stuff, but at some point we have to get off of that train, Your Honor. This is a case of immense public interest. This is a case of, First Amendment issues, and I know we may disagree on that, but that's what our adversary system is for, and that's okay. And I think every case,
Yeah, there's definitely some First Amendment issues in this case.
Starts with
I don't know how that will play out in the end, but depends on the details. But
and that's what we
there's
have here.
definitely some
But
First
in any
Amendment
event, Your
implications
Honor,
in this
I think
case.
we can agree that this case brings to the fore really important issues about what is witness intimidation, what is journalism, where does the First Amendment fit in, and these text messages about and I'm trying to not speak of them in open court, but we all know what they say, and we all know that there's a public interest.
If Aiden loses this and wants a lawyer to go to the Supreme Court
So,
for him, I'm available.
I'd
like to put my claim down. I'm available.
Or someone's phone number.
I'll take
We're
this
asking
case
for
to the Supreme Court.
of these communications that these folks have issued between and among each other, and
We'll do it for
content
cost.
of them per se has no persuasive power to make you want to impound them.
Let me ask Mr. Cosgrove, what interest at the moment does impoundment serve?
Your Honor, I've just been handed,
Excuse me.
20 minutes ago, a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law. I would like an opportunity to file a written response.
I'd give you that. Was a week enough?
I'd like a little more than that, Your Honor.
About 2 weeks.
All right.
There you go. I'll give you 2 weeks. I'll take it under advisement. And if you want to file anything else, Mr. Bradel, Mr. Betterow, you absolutely have every opportunity.
Thank you very much, Your Honor. And
Now, Your Honor, with respect to the items that I was going to turn over today.
So I'll allow the motion. Mr. Bradel, I'm up here.
sorry, Your Honor.
It's all right.
I thought I had a minute.
That's fine. You got to talk to your client. You got to talk to Mr. Betterow. My point is this. If you want the stuff today, I'll allow it without prejudice.
Sure.
And then I'll see what you have to say and what Mr. Cosgrove.
We have to take the candy.
That's fine.
All right.
They're a little obsessed about taking candy.
Thank you.
Yeah, no, that's
Do they have a
fine.
white van that we don't know
I will
about?
allow Mr. Cosgrove's motion without prejudice, and I'll take any submissions that you have, and I'll give you a final answer probably in about 3 weeks.
Thank you very much.
Does that make sense? Okay.
And then, Judge, just to shift gears a little bit, there's some outstanding discovery that we've been talking about.
Yeah.
And
There's more?
I want to start off. I know that the court's time can be much better spent than discovery disputes. So we talked about the idea that we would go to the DA's office, and to the extent there's items that the government says they've given us that we can't open up or figure out.
Yeah.
I think we're going to agree to go in person with our people and figure it out. So
yeah, sure.
That's the first thing I want to say. But then, in addition, Your Honor, there's this inventory that I filed. It's entitled Inventory of Outstanding Items in Connection with Our Third Motion to Compel.
Okay.
There's about 10 things, Your Honor, and I think, unfortunately, that the government ought to go through and answer to us today about what the status of these things is. And we've been kind of going back and forth about these things for a long time. I looked back, Your Honor, and my first discovery request was February of 24. And second and third, were the months following. And in fairness, counsel for the Commonwealth was not the prosecutor of record at the time. But, the rules are the rules, and we need this stuff, and it's gone on way too long. So these are the 10 things that I think are very important, and maybe 9.
Mr. Cosgrove, might you want to take that 2 weeks and respond to all of those,
Could you give me an extra week, Your Honor?
an extra week?
Thank you.
All right, but it is, Mr. Bradel makes a very good point. As we all know, I think that it's important that the discovery be turned over so that we can bring a timely trial to the case.
I don't disagree with Your Honor. Notwithstanding that Mr. Bradel has some complaints, and some of them may well be legitimate, there has been a substantial amount of discovery turned over in this case.
Yeah. If you're turning over 5,000 pages today, it's a lot of discovery.
We appreciate it, Your Honor.
Okay, great.
Thank you. And Attorney Bettero has a number of items as well, Judge.
Mr. Bettero.
Thank you, Judge. Just going back briefly to some of the issues about impoundment.
Yeah.
There are some items that are currently under impoundment, which we believe ought to be released from impoundment, specifically messages from Michael Proctor and a civilian witness. Those messages were cited in our motion to dismiss. As the court is no doubt aware, Michael Proctor is terminated from the state police.
He sure is.
Been a matter of public interest with his involvement in both the Karen Reed case, which led to Mr. Carney's interest, and ultimately, on some level, his indictment in this case. But also, those messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct. The messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption of public access to those files. Michael Proctor has surrendered any privacy interest he has by addressing those issues, as has, the other civilian that we're talking about, who also recently appeared on national news with other members of her family defending her and her family's conduct in this case. Those messages should be publicly available. If there's going to be information that's in the public realm, there's no reason why information that the prosecution wanted concealed from public view should be concealed any further. If the court likes, we can approach and show you the messages. I would suggest they are relatively straightforward, and there's no reason for those to be impounded at this time.
Okay.
Yeah, release the evidence. That'd be good.
I'm not going to give you another week.
Well, I would suggest it would make sense to take this up when we take up the other matters.
I think that makes sense, too.
Yeah, I won't ask for another week. I won't ask for another day.
That's, why don't I do this? Why don't you all come up to sidebar? Let me take a
sidebar. Sidebar. Little sidebar time. We missed our sidebars, didn't we? We missed our sidebars. Yeah, it's all sidebars, baby. Why don't you come up to sidebar? Sidebars is where it's at. Lord. Beep. Now we got beeping noises. Apparently beeping noises means sidebar. Beep, beep, beep. Beep, 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 beep. Either that or someone's heart is very, very slow. One of the two. Someone has a very slow pulse. If your pulse is this slow, you might want to see a doctor. What is this, 30 beats a minute? Yeah, something like that. If your pulse is 30, we probably need to have a discussion with somebody. That sounds low. What do you think, doctors of the chat? Do you think 30 beats per minute is kind of problematic? It might concern you in some ways if it was your patient. You seem to have a pulse of 30. Is that gonna raise a question mark in your mind? Pulse of 30 can be just fine for high fitness individuals. Really? Okay, I'll take your word for it. You got a 40 from beta blockers? Okay, well, there you go. Maybe it's not that big a deal. All right, I stand corrected. Fair enough, I guess. What kind of candy does the prosecutor have? Chat. And what?
You go back.
Why aren't they giving me the candy?
Mr. Betterow, the floor is yours. What else
Thank
do
you.
you have?
Judge, one outstanding issue relates to the second of the three indictments that relates to Lindsay Gaetani. We moved and were granted a hearing to disqualify Mr. Mello from prosecuting that case because he is an essential witness in that matter. That issue was decided in September of 2024. A hearing was ordered in January of 2025. For reasons which the court is familiar with, that hearing has been put off. Nevertheless, we're looking to move this forward, and the issue is not resolved, and we're led to believe that Mr. Mello will not voluntarily withdraw. For whatever reason, we need to do this hearing. We believe that he's going to be a defense witness in this case. We're getting discovery between him and another civilian witness today, which I think is going to further that application and very likely make him even more a prosecution witness, and we just can't kick this can down the road for close to a year. So we would like to schedule a date for Mr. Mello to either appear, be examined under oath, explain the consequences, which the court, again, is probably familiar with. He was contacted by the complainant during the alleged crime repeatedly, 4 or 5 times over the course of that day. Instead of the police being called, he was an ear witness to these allegations. Respectfully, he needs to come in here, answer these questions so the court can issue a decision as to whether he's going to be allowed to continue or whether we can go through the process of subpoenaing him and any other items that might be of assistance to us with calling him as a witness.
Mr. Cosgrove.
Could I inquire if Mr. Mello is online?
I do not see him. Attorney Mello, last time he did use his name, there is no one with his name on there this time.
Can I approach?
Of course. Come on up.
Okay, more beeping noises. Beep. Beep, beep, beep. By the way, for today's watch, I am flexing my Citizen Pro Master Tough today. I like this watch a lot too. My Zen 1 is still being held hostage by UPS as we speak. No apparent updates, although it has now had an import scan 4 or 5 times at this point. How many import scans can there be? But there's got like 4 of them in a row, or 5 of them in a row. The seller contacted me today, like, what's up? I'm like, I don't know what to tell you, man. It's still being held by UPS. Here's the tracking number. I don't know what to tell you. Yeah, I like this watch a lot. I like this watch very, very much. This is a very cool one. This is called the Ray Mears. Ray Mears is a British survivalist guy, kind of think like Bear's Grill, and he wore this watch a lot, or at least a version of this watch a lot. He wore this a lot on his television program, so the watch became named after him, as you might expect. This is a very, very cool watch. Very legible, solar powered, 200 meters water resistance, titanium, very scratch resistant, shock resistant, magnetic resistant. Does everything, man. It's great. I think it's just like minimal standard magnetic resistance. I think it's only like 60 Gauss, but still, So it's not like super magnet resistant, but 60 Gauss is still a fair amount. So. Do I have any Seiko's
Mr. Barrow,
watches?
you said you had one more thing.
Yes, Judge.
I don't think I do at
Just
the
as it
moment.
relates to discovery, we have made a series of discovery demands from the prosecution ranging from October of 2024. As of this date, not including whatever was filed today, we have made 4 very thorough, detailed discovery demands sourced regarding contacts between a civilian named Catherine Peter and the state police and the district attorney's office regarding her very unique relationship in all matters involving Mr. Carney. Those demands, which again are in the files, Mr. Cosgrove has them outlined in detail, her frequent contacts with the state police, with people that are prosecutors, statements that she has made under oath in court proceedings stating that she helps authorities get Mr. Carney, voice recordings that she has left Mr. Carney indicating that she provides information to them. So we have asked for any discovery related to Ms. Peter going on about a year. Now, today, for the first time, we are admittedly getting something that relates to her communications with Mr. Mello. I'll only note that all materials that relate to Ms. Peter and the prosecution were ordered by the court in early May to have been provided within 20 days. That didn't happen. We got stuff today. That's fine. But the real issue here is that in light of the change in Rule 14 from last March, the game is very different than it might have been before in terms of what the prosecution is obligated to do and what I don't believe they've done in this case, which is go to every member of the prosecution team, which is everyone in the district attorney's office, any of the state police who are involved in these matters, which includes Michael Proctor at the time, Yuri Buchanan, Lieutenant Tully, Fanning, there's a whole list of them. The Karen Reed prosecutors who are also covered, who got a little bit involved, as the court is aware, in Mr. Carney's case and may or may not have had a relationship with her too. She has made statements allegedly indicating some involvement in that case. The rule requires the prosecution, whether they credit the information or not, to contact each individual that is on the prosecution team and make an inquiry and find out whether there is any material and disclose it. We don't think that that has happened. We respectfully submit that is something that Mr. Cosgrove has to do. In particular, I would draw the court's attention to testimony that was given by a member of the state police in February of 2024, which led to a wiretapping charge against Mr. Carney, in which Fanning of the state police stated under oath that they received a recording, a 30-second recording from Catherine Peter, that it was given to Lieutenant Tully and then given to Fanning, and we have no evidence of that. We don't have a copy of the recording. We were given the wrong recording in that regard. We have no police reports. We have no communications. We have nothing. If they don't exist, they don't exist, but they're obligated to look for it, make the inquiry, and report back and say whether any of this exists or not. And the last thing I'll note on that point, under the new rule, it doesn't matter whether the prosecutor credits any of this, thinks it's nonsense, thinks it might be real, they're obligated to do it. And we simply ask respectfully that the court instruct the prosecution to do that and disclose whatever evidence ought to be disclosed, or make a statement on the record that there is nothing to disclose. And if that's the case, then we'll all live and die with the consequences of that statement.
Okay, Mr. Cosgrove.
Largely been done.
Is that part of the 5,000 pages that you're turning over?
6,000.
It is. Among the things turned over is the email from Catherine Peter to Brian Tully providing that 30-second clip.
Gotcha. Okay, that's fine. So that seems to solve that. you said that you had some things you wanted to bring up. Go right ahead.
Yes, yes. So this will be an opportunity, Your Honor, for myself and Mr. Betterow to do an absolute 180 on our positions on disclosure of impounded documents. Your Honor will recall that the last time we were here, attached to a discovery motion was an affidavit.
Oh, yeah.
And at that time, it was initially filed provisionally without hearing from the Commonwealth, was impounded upon, I believe, not the affiant's representation, but I think Mr. Bradle's representation that the affiant was in fear that there would be some sort of retaliation by the Commonwealth. I think Your Honor will recall the fairly outrageous, if I can put it that way, representations that were made by the affiant. I believe now, as I moved at the time, that that affidavit should either be stricken or that the impoundment order should be lifted. I don't believe an affiant should be allowed to accuse an assistant DA of jury tampering and a district attorney of having secret meetings with witnesses and all these other things, and then hide behind an impoundment order.
Okay. Let me hear from the other side. Mr. Betterow.
Yes, a couple things that I think ought to be corrected. The affiant is not alleging what happened. The affiant is alleging under oath that she was told by another individual who we were discussing earlier what happened. That's the first point. The second point is that document was attached as an exhibit to a discovery demand. Discovery demand number 4, alleging more reason to believe that there is an obligation for the prosecution to look into possible discovery that is in their possession, custody, or control. If that affidavit were to be stricken, that means literally nothing. They are still obligated to do whatever it is they had to do. And at the time that that motion was discovered until 20 minutes ago, absolutely nothing has been turned over regarding this person who brags about working for the authority. So I don't know the relevance of doing anything one way or the other with respect to the affidavit. Now, that person may very well have a privacy interest because the day after that affidavit was filed, her apartment was essentially covered in personal information about herself that could have only come from someone with access to law enforcement, and almost certainly that individual was subjected to charges of witness tampering, which I believe were actually under investigation and may still very well be. I can't go farther than that. I don't know. Somebody, whoever did this, wrote snitch on her door. So I would suggest in this situation, impoundment of her name is more than appropriate.
Okay.
Just make 2 points in response. One, I don't think it's entirely true that the affiant was simply relying on recounting hearsay. If she was, that would say something about the credibility of the affidavit as well. But I seem to recall, Your Honor, that at least one point the affiant represented that she was present when Ms. Peter, I believe it was having a phone conversation with Hank Brennan, and that she, the affiant, recognized Hank Brennan's voice because she was familiar with it. So I don't think it was simply a matter of hearsay. The second thing I'd say is that the identity of this person is all over the internet, and was all over the internet at the time it was before you the other day. I don't know what the interest is, given those circumstances, in concealing it in the court papers.
Okay. Judge, I'm sorry,
and I'm sorry.
I'm sorry, go ahead.
Could I just add one thing?
Yeah.
apparently these things that were affixed to her door in her apartment building, which is the same apartment building that Ms. Peters lives in. And I think the implication was made at the time. First of all, that event was publicized by Mr. Carney on the internet with photographs of the door in question. And I guess I would just question, Your Honor, the source of those documents, let's put it that way.
Okay.
Just very quickly, Your Honor, in terms of this individual's name being on the internet, there are two reasons for that. The first is because Ms. Peter identified her publicly and led to this kind of harassment. The other reason, and this was no question a mistake, but Mr. Cosgrove mentioned her name accidentally, and no question, no malintent, but her name was stated in open court, and as you can see, people watch in court, online, and whatnot. So the fact that her name had been put out accidentally through no fault, with no malintent, is not a reason, I think, to just open up the affidavit to her name.
Okay, thank you all. So we have a date for, what was that, August? What was the date, Margaret?
August 13th for discovery
August 13th.
compliance.
And then we'll pick a date for the other issue. Am I correct, Mr. Cosgrove?
Yeah.
Towards the end of the month?
Now, if you want to pick it on.
Why don't we pick it on the 13th? I think that makes sense.
All right, I may have some, I'm sorry, I should be standing.
That's okay.
I may have some information about
That's fine.
the health status at that time.
All right. We'll see you all on August 13th.
Thank you.
Okay, thank you all.
One more, Your Honor.
Go ahead.
Oh, sorry. I believe we have an agreement. Mr. Bradel has responded relative to the source code for accessing the search of the devices.
Yep.
And he's indicated there was the same source code previously provided Lieutenant Tully, and that he would supply it again if necessary. And I've indicated to him that that's appropriate, and I think he should supply it today. And I don't think there's a disagreement with that.
All right. You don't disagree with that, do you? Sure. Yeah, all right, good. I'll see you August 13th.
Thank you.
All right, take care. Bye.
2 p.m.
2 p.m.
Thank you.
We have any lobbies we could go?
Yeah, we're gonna take that. We'll take it across the
Yes.
street.
Yeah.
Get out of it. Just get out of
I'm
it.
not aware that, I'll check on that. I know I saw something where she said in a text message to this Jean lady, this message she said,
Thank you.
Thanks.
Yeah. Yeah.
Okay, next is for the court number 18, Palma versus Lokeshwar Chinzak Kunta. I apologize for that pronunciation. The parties could please step forward and identify themselves for the record.
All right. Well, that is the end of that hearing. So the case continues with respect to witness intimidation. And apparently with respect to this case, this particular witness intimidation case, there's 6,000 pages of discovery. How can there be 6,000 pages of discovery on a witness intimidation case? That's a lot of discovery. What are we doing over here? That's a lot of discovery. For a witness intimidation case, Lord have mercy, man. Like, okay, but apparently we were just cranking out the discovery pages, and he's supposed to get the discovery, and like today, I think. And that's basically it. And there's no trial anywhere in sight relating to this. They're introducing all of Turtleboy's blogs as evidence. That's fair. Okay, that makes more sense. So if they downloaded like all of his blogs that were from the Karen Reed case as evidence, then that makes sense how they're getting to 6,000 pages. Okay, fair enough. All right, that makes more sense. Yeah. All his tweets and stuff. Okay, yeah, that makes more sense then. Fair enough. So that just seems like a lot of stupid. And yeah, I agree that there's a First Amendment issue lurking here. I don't necessarily know what the boundaries of that are. It's a little unclear, but it sounds like a lot of what Aiden Carney did is just journalism as opposed to like intimidation. And you don't need a press pass to be a journalist because the Constitution doesn't change. The Constitution doesn't recognize anyone's rights more in a First Amendment context. Everyone has the same First Amendment rights. So whether you're a member of a newspaper or a radio station or just an independent, you have the exact same freedoms as anyone else because they're individual rights. And so you don't get more rights because you have a press pass. In the First Amendment context, you don't get more rights. So you can still kind of write and do kind of anything. And so there is a latent First Amendment issue here in the background. So if he is convicted of some of these charges, then depending on the details, there could be a very realistic First Amendment case to be had. And it could hypothetically go to the Supreme Court because, you know, if you can make out the case well enough, you know, then you could, you might be able to get to the Supreme Court of the United States. So I think there's a chance of that happening. Depending, of course, on exactly how it shakes out in the evidentiary case. So if he did things that are more suspect, if he did things that are more aggressive, then, you know, the First Amendment does not protect action, it protects speech. And so depending on what exactly he did, but if all he did was like try to interview people like by knocking on their doors and stuff and trying to interview them, press do that all the time. If he tried to interview them in a public event, then that would, unless they had told him to leave him alone, right? Then they could get him on maybe a harassing charge or a stalking charge if he told him to leave him alone, because the press doesn't have any right to like continue to hound somebody any more than anyone else. But, you know, short of that, I feel all he did was try to interview them in public places. If all he did was try to knock on their doors and interview them, and he didn't do anything else other than that, then I think that, you know, the First Amendment context would be likely to protect it on an as-applied challenge. I don't think you could challenge the statute on a facial challenge, because in order to challenge a statute on a facial challenge, you have to show that there is no valid use of the statute. You have to show that every or almost every application of the statute is invalid, which doesn't seem to be the case here. That doesn't seem to be the case. There are valid applications of the statute, to be sure. But on an as-applied First Amendment challenge, there's definitely something there. And especially if you could reveal in the discovery or otherwise any explicit improper motives by the police or someone else, if you can show that if you can show an improper basis to investigate him because they didn't like what he was saying, then that would go a long way too. So, of course, a lot depends on discovery and a lot depends on the specifics. But there is a First Amendment case to be had, potentially, if he's convicted. And potentially, depending on the details, of course, it could go all the way to the Supreme Court of the United States. And if it does, I'll be more than happy to represent him for cost. You know, I'll need my costs paid for because the printing alone is fairly expensive from a major printer. The printing is very expensive because Supreme Court uses special paper that no one else uses. So you have to get it done specially. Even if I got it done locally, specially, it still costs a couple $100. If I get done by the real people that do it, though, it's a couple $1,000 just to print it. It's a pain in the ass. Not for at least the reasons you need like 40 copies for some reason. So you need 40 copies of, I don't know why you need 40 copies, but you do. And in any sense, it's like, yeah, you got to do all those things. So good times. All those things. Yeah, it's like it's a weird dimension. It's like 6 1/8 by 9 1/2 or something. It's a really weird dimension paper that no one else uses for anything. Supreme Court has their own special paper just for them. They can't use 8 1/2 by 11 like a normal person. They got to have their 6 1/8 by 9 1/2 bullshit. It's really whatever, man. What does the witness intimidation statute say? It's very broad. I could pull it up and see what it says verbatim, but it basically says that if you contact a witness or prospective witness or a family member of a witness, in a way that causes physical harm or emotional harm with intent to dissuade them from testifying, then that's a crime. And so the thing that's sort of saving it is the intent to dissuade them from testifying. That's the tricky thing. But I don't necessarily know how you prove that intent based on the actions that are alleged. Yeah. So all that stuff. They should go back to dot matrix? Maybe, man. I'll tell you what, yeah. Just a really, really weird paper size. I don't know why they do it that way. It's just very, very weird. Of course, if I could get him declared indigent, I think I can use 8 1/2 by 11. So if he's so poor that he can't afford it, then I could try to get him declared indigent, and then I think I'm allowed to file 8 1/2 by 11 paper instead of 6 1/8 by 9 and whatever paper. So that would save me a lot of money. I still have to print 40 copies though, so I'm still going to need like a couple of reams of paper, but you know, hey, it's not that much. It's not that expensive, right? So I'll need a couple of reams of paper, and I'll need to ship it to the Supreme Court. So that'll cost a little bit of money, but it'll be cheaper. Although the Supreme Court doesn't really super like indigent petitioners, they don't really grant a lot of those. It's not really the smartest way to go if you want them to hear your case. Yeah. They get a lot of stuff filed by indigents that's just shit. So they are not super receptive to indigent petitioners. Yeah. Is there not a service in DC that will print and deliver it? Sure. Yes, there are a couple companies that do it for several $1,000s. Yes. So there are companies that professionally do this for the Supreme Court. Of course there are, that are in the greater DC area. Sure there are. And they will happily print it for you, and they'll even check it for you to make sure that it's correct. And then they'll charge you several $1,000s to do it. But yes, that is the typical way to go about this. The professional companies. Yeah, it's expensive. The paper is outrageous. Yeah, the paper is outrageous. I've known of attorneys who've done it themselves, though, printed it out themselves and then cut it to shape. That is really fucking tedious, though. As in, well, the real problem, even then, even if you did that, it has to be bound in a special way. It has to be bound. There's very, very exacting rules. The paper has to be a certain thickness, and it has to be a certain color. I forget if it's like what shade of white, but it's specified. It has to be bound in a perfect way, in a special way. It has to be done in a very. They're very particular about what they want. Yeah. And they require you to print it and do it in paper, even though then you electronically file it too. Which is like, why? Right? It's like you're going to require me to print 40 copies of this thing and send it to you, and then also electronically file it. Yeah. I've never seen a brief on the merits that wasn't professionally printed because the rules are so complex. Yeah, fair. Fair. Yes. Yeah. Trooper David DeCiso was reassigned. Yeah, we announced that a little bit earlier. Yeah, a lot of people getting reassigned. He got reassigned. Buchanan got reassigned. Proctor's gotten fired. Dever is out on leave. A lot of rats in this sinking ship, man. Is there any way for potentially criminal to come up through Discord? We could give it a shot. Yeah, we could try a Discord thing. We've never done it before, but let's give it a shot. Why not? Let's give it a shot. Let's see. I guess I'll use staff voice chat. Neat. All right. Well, if potentially criminal wants to join us, we'll give that a shot. Can I flip my camera? In Discord? Yuri Proctor, Dever, and who? It was I don't know. I'd have to scroll in chat to find it again. Yeah, we have a stream set up. We're just waiting for you for potentially criminal to join. I'll invite potentially criminal. See if he joins up. Why is Dever on leave? Unspecified. CISO, that's right. Yep. We'll give him a second to see if he wants to pop on. I could record a script while I'm waiting for him to join. I was waiting to do it anyway. See how long I have until he pops on. We could do a little script reading for a story. Anyone watch my video that I posted today? The edited video on demand? What'd you guys think? Was it good? Not good? Need more? I don't know. He's done with Courtney. Might need a minute. Okay. DeChico? Ah, okay, fair enough. DeChico. I enjoyed it. Cool. Andrew said I was posting one. Yeah, I posted it at noon. It was good. I'm glad you liked it. I have one today on Thomas, the swimmer. Let me pull it up and try to see if I can record this. Let's see. Envision a university that in its quest. Okay, good. It's working. All right. She's broadcasting Turtleboy outside the courthouse. All right, let me see if I can find that. Where that's happening. Let's see. No. No. I don't know where she's getting this feed from. No. 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 Okay. I don't see a live feed outside the courtroom anywhere. I hate hunting for things on the fly. From Young Jerks. From Vanity Fair. No, that's not it. Young Jerks has a feed. Okay, let's check this one out. Let's check it out. All right, let me give me a second to pull this up. Okay. Cool. All right, let's watch this outside the courtroom for a little bit. Up.
I'll bring it to you. Look 'em. Go ahead. That's bad.
Carney. I know they added that kind of document that pumped on you today. Yeah. 5,000 pages. Probably, you don't be.
But, I may have missed it. How are you? We talked a little bit about things, attorney Mello from this case. Have you spoken to him?
Haven't spoken. I think, you know, it's been papered, you know, case, heard on it. We're just gonna call back every file on it. At this point, we're just trying to get a hearing, so we can, you know, make our arguments that we've laid out.
Have you ever seen, had your attorney that started off that left the case and is now witness in the case? Obviously, based on communications with Lindsay and Kate, this is a very interesting situation.
I've never had a case where a prosecutor got involved with the witnesses and then became somebody that was going to have to be potentially testifying as a potential impeachment witness or a fact witness, getting calls at 3 o'clock in the morning, you know, while my client's in the house. It is unprecedented.
What do you make of the judge's kind of jovial, laid-back vibe today? He seems in a great mood. He laughed a lot. Can we interpret that as him not taking this seriously? How should we interpret this?
No. Judge Doolin is the best. You don't get any better. He's been around. He's walked the walk. He was in the DA's office, been a defense lawyer forever.
I noticed you took part of the hearing.
Yeah.
How'd that go for you?
Was it worthwhile? Yeah. Find out.
Lauren,
Don't know what's happening.
we can't talk about it.
Can't talk about it. Apparently you're allowed.
So how did they win? Are you comfortable with it?
Oh, yeah. We've got a lot of stuff out there. Big thing is all this discovery, it's impoundment. And we've had it for months and months and months, and we can't talk about it. There's nothing to talk about it. It's in the public, this stuff, there's just this cloud of secrecy that exists in North County. And do whatever they want, and no one else gets to know except them. Not how the United States of America.
Anyone cares, but.
It's kind of jovial at times. Less yucking it up with the old boys. But I know how it works. You got the judge, he knows the attorneys, they're together on a lot of different stuff. You sitting there kind of monitoring it, feeling you took it seriously.
Oh, yeah, I mean, but just, I can't just talk about what we just.
I do a selfie. Give me a. And now we're looking at. How do you feel about that? And how do you feel about the integrity of this type of investigation case, knowing that they now are testimony in regards to these witnesses?
Well, it's undeniable that it is a. Instead of
Like court was more like a fan records still. So, I mean,
yeah, he's still on all the emails.
that's ridiculous. I mean, why is
You have to ask him. Yeah. Yeah, you'd have to ask him. How was the day for you? Day was fine. So, just as far as the Miller situation, there were issues, obviously, but the bottom line is never in 26 years have I ever seen a situation where an alleged victim of a crime calls the prosecutor in the middle of the night or while the crime is happening instead of 911 for the police. Once that happened, he made himself a witness, and that's the way it is, and that has to be resolved. He's entitled to a fair trial. He's entitled to a trial without conflicts, and we're entitled to call someone who is a fact witness. So the fact that you have to see the prosecutor, as incredible as that is, it's not a basis to get a pass. So we fully expect that we will have him removed from this case and potentially subpoena him and have him testify. And I think it'll be favorable.
How confident are you that you are going to receive all of the discovery that you've asked for in 3 weeks?
We'll have to wait and see. I take Mr. Costco at his word. He did jump on this late. Other people were involved beforehand, but we're entitled to what we're entitled to, and we're going to get it. And we'll continue to complain that we do. And again, that's the centerpiece of a fair trial. We're entitled to material. We want it. If you don't give it to us, that's like your own problem.
Elaborate a little bit more on your statement regarding Michael Clark. You said that the press for that the expectation of privacy has kind of all gone out the window at this point. Can you talk a little more about that?
Michael Crawford is a disgrace, corrupt former state trooper who was terminated for his conduct in the case that Mr. Carney covered, and that same agency is the one who arrested him. There are communications which are impounded, I'm not going to get into them, that I think would shed a lot of light onto that. Now, as far as them being impounded for witness privacy issues, this man went on a press tour a few weeks ago and emphatically denied doing anything. We don't agree with that. But if you're going to put out piecemeal coverage publicly, trials are supposed to be fair, open, public access. The public ought to see exactly what he was saying and who he was saying it to before he was arrested and why that was. It's just public access and part of fair trial. That's all.
So who's the Commonwealth protecting him?
I'm not going to speculate on who they're protecting. They seek impoundment of virtually everything, which is the antithesis, again, of what a fair trial is. There should be a presumption of openness. There should be light, not darkness. But for whatever reason, in this county, in their high-profile cases, they seem to have a presumption of darkness. We don't accept that. All right. Thank you, guys.
Okay, that was pretty cool. I mean, yeah, presumption of darkness, keeping everything under seal. Pretty much. It's like they don't want people to know the truth about what's really happening. A lot of cover of darkness, man. A lot of corruption. Like, yeah. Like very seedy, incestuous up there. Very disturbing. And in the case of Brian Walsh, let's see if I can read this full statement. Hold on. Where is this thing? All right. Let's read this thing. So the Commonwealth, in its infinite wisdom, filed this bit of glory in the Brian Walsh case relating to Michael Proctor. Why is it not? Okay. Why is it not? All right. My thing is not behaving the way it's supposed to, and it's driving me a little nutso. When I hold down Alt, it's supposed to just change the one dimension. It's changing all the dimensions of the screen, which is really annoying me. All right, we'll just do it the hard way, I guess. They filed this beautiful statement. It's not dated. It doesn't look like. Commonwealth's notice regarding State Trooper Michael Proctor's work phone data. Exciting. In January of 2023, Trooper Michael Proctor was designated as the case officer in the missing person and murder investigation of Anna Walsh by the Massachusetts State Police. The Cohasset Police designated Sergeant Harrison Schmidt in an identical role. The Massachusetts State Police and Cohasset Police devoted dozens of additional officers to the investigation. Indictments issued on March the 31st of 2023. At the time of the filing, the Commonwealth does not intend to call Michael Proctor to testify in this matter. Now, that right away, again, is like, he is once again your case officer, otherwise known as your lead investigator. And you're like, yeah, we're not going to call him in the Walsh trial either. Commonwealth has many problems. That's exciting. The trial of Commonwealth versus Karen Reed began in Norfolk Superior Court on April 16th of 2024. Trooper Proctor testified in that matter on June the 10th and 12th and was subject to cross-examination relating to alleged conflicts of interest, communications with non-involved civilian persons regarding the Reed case, and statements regarding the defendant from which defense counsel argued bias could be found. On August the 14th of 2024, the Commonwealth provided an unofficial transcript of Trooper Proctor's testimony to Reed's counsel. Also, the Commonwealth provided counsel with a letter disclosing the results of inquiries pursuant to Graham and McFarland, which include that Trooper Proctor had been suspended at that time without pay. It got a little bit worse later. On August the 29th of 2024, the Massachusetts State Police provided an extraction of Trooper Proctor's work cell phone data to the Norfolk District Attorney. On September the 4th of 2024, the Massachusetts State Police provided content from Trooper Proctor's work cloud account to Norfolk District Attorney. Based on the Norfolk District Attorney's Office preliminary review of the data, and because the extraction of Proctor's work phone and cloud is expected to contain, among other things, information about open investigations, surveillance video from unrelated investigations, personal identifying information and/or medical identifying information from individuals involved in unrelated investigations, location data of Proctor and third parties. Releasing the entire extraction report outside of law enforcement is anticipated to jeopardize open investigations, compromise the privacy and safety of civilians, and thus be contrary to the interests of justice. Cute. And then there's a whole footnote, which the footnote is big, man. This is a big ass footnote. The phone and cloud accounts may contain sensitive and confidential communications and information relating to unrelated cases and investigations. This information may include criminal offender record information, the names and contact information of confidential informants, the names and contact information of civilian witnesses and victims, including minors, impounded search warrants, state updates of covert ongoing investigations, information about ongoing grand jury proceedings, autopsy records and photographs, and other sensitive, privileged information that, if disclosed, would not only jeopardize law enforcement's efforts, but could pose a physical safety risk to many people. He's got a lot of information on his phone, man. A defendant's unrestricted access to these devices would also likely violate statutory privileges, serving to protect unrelated cases, investigation, witnesses, and victims. Additionally, the professional device of a municipal or state employee could include sensitive personal information about that person, such as human resource documents, payroll information, including bank account numbers, personal identifying information such as social security numbers and home addresses, and sensitive medical information, all of which is statutorily exempt from public disclosure. And then the Norfolk District County's office exploring hiring an outside firm to examine the phone and cloud data to ascertain what is discoverable. Oh. Accordingly, the Norfolk District County's office is in the process of ascertaining how to determine what, if any, information on Trooper Proctor's work phone or cloud account is discoverable in this or other cases. On September 6th of 2024, a Zoom hearing was held in Commonwealth versus Julius Hammond Desire and Samantha Schwartz. The Commonwealth reported it was in the possession of Trooper Michael Proctor's work phone and cloud. The Commonwealth indicated it was exploring whether to hire an independent firm to examine the phone data. Both the court and defense indicated it was their position the Norfolk District Attorney's Office had the obligation to conduct the search of the phone extraction. Accordingly, in Commonwealth versus Julius Hammond Desire, and Samantha Schwartz, the district attorney will follow the court's directions, search the data for bias and Rule 14 material. The Commonwealth will be willing and able to conduct similar searches for this case. The Norfolk District Attorney's Office also intends to explore continuing to retain an independent firm to review and examine the records. Very exciting. So the Michael Proctor shit show continues unabated, which, you know, we all kind of saw that one coming, to be sure. We all pretty much saw that one coming. So that's exciting. And let me guess, it's all undiscoverable? Probably. Yeah, we've done a thorough search and we found nothing to share with you. Yeah, probably. Michael Proctor is a poison to everything he touches. Unsurprisingly. He has work phone, yeah, 100%. I'm just waiting for potentially criminal to come because apparently he's going to be coming soon. So I'm just waiting for him to show up. The stupid is very, very real. It's insane. Just imagine if Karen Reed took a plea. Yeah, no doubt, right? But yeah, she didn't. Thank God, and thank God the jury acquitted her of everything except the DUI, which they should have absolutely, because the case blew chunks. I have enjoyed the anti-Karen Reed people screaming into the void online about how this jury is completely dumb. It's like, yeah, that's definitely the problem. I mean, apparently every single juror in both trials found against the murder and leaving the scene of the accident charge. So that's like 24, that's 0-24. You got 24, and also the alternate jurors apparently all agree too. So that's like at least 30 people. So apparently 30 jurors are all complete morons and thought the state failed to prove murder and, you know, leaving the scene of the accident. That's definitely a problem. It's just that 30 people are complete idiots. That's definitely what's happening. He's trying to use an old Restream link. Yeah, but it's on Discord because I can't. The Restream link is dead. I invited him to Discord, Mandy. I gave him an invite, so hopefully he'll show up. Can we send those people into the black hole? The mysterious black hole, if wishing made it so. If wishing made it so. Yeah. Buchanan was reassigned to a temporary administrator for all divisions of standard and training. Nice. No, he's going to be teaching people how to be a cop. That's great. Lol. Would you want to take a class from Buchanan on how to be a cop? I mean, come on. Desk job, 100%, yeah. I need a caffeine. And I need to go to the gym pretty soon. So hopefully Sean will show up pretty soon because I'd like to get a caffeine and I'd really like to go to the gym today. I should have gone first thing this morning is what I should have done. But having blown that play, I need to go to the gym now. I downloaded a new fitness app. We'll see if how this one does. So we're giving a new fitness app a try today. So we're doing this app called Gravel today. And we'll see like how that works. No supersets. I don't do supersets. No supersets. No supersets. I don't like them because it just takes up too much time at the gym. And also it's kind of rude to other people to superset at the gym because other people might want to use that equipment. So I don't do supersets at the gym. What does the app do? It's an AI fitness app. So it keeps track of your activity at the gym and then recommends workouts and progression and stuff to make you stronger. It's basically like an AI personal trainer is the idea. So we'll see if this one's any good. You did a superset of 8 goblet squats to 8 backward forward lunges. Yeah. You did some in your morning in this workout. That's cool. Yeah, maybe the gym that you went to is less busy at that time of day or something, but I don't like to do supersets because then you're using multiple pieces of equipment at once and it's kind of rude to other people in the gym. So if the gym is really, really quiet, then I guess you can get away with it. Or if you have a private gym or something like that, then you can get away with it. But otherwise, I don't like to do supersets because I don't like to take up more than one piece of equipment at a time. That's the thinking, at least. Kurt's watch is still being held hostage by UPS with no particular updates. It is still being held hostage. There are 1, 2, 3, 4 import scans in a row. There was a scan on the 5th at 2:28 in the morning, but no updates in terms of delivery. All right, well, Sean apparently has stopped responding, so I guess he's not coming, but we gave it my best, so we tried, but we're not going to just keep around for Sean. So I'm going to take a caffeine and I'm going to go to the gym. And that'll be fun. So I'm going to do all that stuff. So we'll see. We'll see. Then I still have this watch, this watch, which I like a lot too. It's quartz and it's shock resistant and magnetic resistant and scratch proof and everything else. It's a good watch. I wish the size was a little bit smaller. The dial is only 38 millimeter. The actual dial is only 38 millimeter. Like the case is like 41 millimeter, I think. The dial is only 38. I wish it was a little bit larger, but it works. All right. I'm going to sign off for now. Love you guys. I will talk to you soon. Till later.